But anyway, no, it's a pleasure to be here. My name is Josh Halleck. For those who don't know me, I know I've met several of you already at one of our Saturday seminars that we've had in the last month, I guess. So had a very good showing at that Saturday seminar. Really appreciate the opportunity to come here and meet with you guys on a regular basis and also to collaborate with RMIA. So I moved here about a month ago from DC with my little dog, Dexter. And the reason that I did that was actually because of you all, when I thought about it. And that is because, you know, the inventor community, the innovator community need to speak up. Oh, okay. Is really critical, you know, to promoting innovation in the United States and economic development, job growth. And I really wanted to be a part of that, a direct part of that, and being able to get out into the community. In Washington, I worked as a stakeholder engagement, advisor to our Undersecretary, Michelle Lee, who many of you are familiar with. She's the first female and Asian director of the U.S. Patent and Trademark Office in our 225-year history, so we're very proud of that. And we're also working towards, trying to promote the role of women in STEM under her, because that's one of her pet peeves. So I don't see any women in the room, so we need to do a better job of that, I see. I'm just kidding. But seriously, the USPTO is doing more than we've ever done in the past. We're really working on building a lot of resources for inventors, for small businesses, for all sorts of stakeholders across the board, making those available to the community. Trying to hold more programs than we have ever done before, collaborating, like I said, with organizations like RMIA, but also with the other federal government agencies, other state agencies, other local agencies, so that we can really work together to make a difference in the innovation community here in Colorado and the entire Rocky Mountain region. As you may know, we're responsible for 9 different states, from Idaho to Kansas and North Dakota to Utah, that big rectangle. So we're trying to figure out how we can most effectively impact that region. And we appreciate your ideas. We're here to serve you. We want to meet your needs. We don't want to tell you what your needs are, which the government has been known to do in the past. So like I said, appreciate any input you would have on the programs and the resources that we have, the website. Please email us, my card's in the back. Mike, I know, would love to hear from you as well. So with that, I'd like to briefly introduce Mike, my dear friend Mike. No, seriously, Mike is a dear colleague and has over 30 years of experience working in the American patent system, which is pretty incredible, I think. He graduated from University of Illinois with a degree in mechanical engineering and then really decided to dedicate his life to public service, working as a patent examiner. And like I said, that's why we're here. We're here as public servants to serve you. So Mike, of course, as you might imagine, ascended through the ranks of the Patent Corps and became a supervisory patent examiner. And not only that, he served to protect the security of this country, our national security by, I don't know if you're aware, but the United States, I just learned this today, actually the United States Patent Office has been delegated the authority to review foreign export licensing to ensure that we're not granting export licenses for sensitive technologies. And Mike was at the center of that for many years. So we are very lucky to have had him be detailed to this office and subsequently appointed to serve as the regional manager and oversee all of our operations. So with that, I'll give you the floor.
Thanks, Ross. I feel like I just received an award. I just noticed that you get a tie, you get a suit. 2 of us will make a government employee. So we're slowly figuring out that things are a little bit more laid back here in Colorado. I'm working my way from the bottom top, as you can tell by my shoes. So anyway, I had a prepared PowerPoint presentation, but given the crowd and knowing a lot of you here, we're going to wing it a little bit. I'm going to go through the patent examining process, tell you a little bit about a patent examiner, and then I'm going to pick this up and go through a couple of tips. But first off, I want to, some I don't recognize. Is everyone familiar with with trademarks, patents, the differences between patents, trademarks, copyrights? No? Okay. So briefly, there's a number of different ways to protect your invention. So depending on what your invention is. If you have a neat if you like the shape of your bottle, if you invented a bottle and the shape of it is really intriguing in some respect. For example, Coca-Cola, the nice curved shape of the bottle. That would be a design application, a patent application on a design. You have the name Coca-Cola. You have a name that's associated with a product that is really taken off. Coca-Cola, if you go to the store and you buy a soda, if you see a generic soda and you see Coca-Cola, you know what Coca-Cola is going to be. So you know that trademark, Coca-Cola, defines what's going to be in that bottle. It's always going to be the same. So trademark is a name, Coca-Cola, Kentucky Fried Chicken, something that identifies a product and the source of goods of the product. Copyrights, books, movies, things like that. Photographs are copyrights. These are kind of things, trademarks and copyrights. Once you have something, you automatically have the copyright, you automatically have the trademark. If you want to register it, that's what you can do to make it official, so to speak, all right? So you have patents, trademarks, copyrights. Hang on, I'm thinking Kentucky Fried Chicken. Trade secrets. So you have trade secrets. So you don't want to. You might not want to file a patent application for all of these applications. What you're doing for disclosing to the public what you have, what the invention is, you get so many years of protection. Maybe you don't want that. Maybe you don't want to. If you have a great recipe for chicken, better than Kentucky Fried Chicken, if you give that up and let everyone know what it is, who's to say that people aren't just going to make it in their house? You're not going to get anything from it. So you might want to protect it as a trade secret. So you can get protections as a trade secret. In each state, they have a means to protect these by various state laws. It protects people from stealing those inventions, assuming that you keep it secret in various certain ways. So you have trademarks, patents, copyrights, and trade secrets. And I think I've pretty much covered all of them. So what I'm going to talk about is patents a little bit. So patents protect your invention, protect something that's not a design, or something that's not a shape of something, or not a name, not a copyright, something like that. There are different types of patents. There's a design patent, the aesthetic appearance of something, so that the way that bottle looks may be a design application. All right. There's a plant application for what do they call it? Type of plant. Non-reproducible. It doesn't. That's my thing. All right. Thank you. Asexual. Type of plant. All right.
I don't want to take too much time. There's a special group that does plant applications.
Yes.
There isn't that many compared to
I don't know. I know there's a
patents are almost $10 million.
how many plant patents, and I think there's one presentation that we do have slides that actually, I think, point that out. Yeah, on our website you could probably find that information. All right, number of plant applications. So plant design and utility applications. So utility pretty much covers everything else. Anything that has some type of function to it. So if you're inventing anything from a table to gears to robots, computers, graphic drivers, anything like that. Anything you can think of, look in this room, anything you think of can be protected by a patent application. Okay.
While being in Colorado, I'm going to ask this question.
I know it's coming up. All right, so no. Trademarks, no. You can't trademark anything. I think it's illegal to trademark a pet, federally illegal. Or yeah, there's a statute that prevents you from doing it. For patent, no. I'd say no. But I think there's ways if your invention covers other things, and it just happens one of the uses may be cannabis or marijuana. But it's a pipe that has some medical use, or a pipe that may be used for smoking regular tobacco or something like that. You can get it if it's just, if there's other uses for it. But I'm not going to talk about that much because I don't know a whole lot about it. It is an issue, and I know that we have some people that can talk about it more. I don't know if you wanted to get to the. Yeah. Yeah.
You may want to mention also the business method, the procedures, right, as a partner.
Yeah, business methods, and we're the only. So a method of doing business. Can you patent a method of doing business? And I believe we're the only country that allows you to do that. It's a very.
Can you have a design patent and a utility patent at the same time?
Yes, depending on what your invention is, and maybe a number of different types of applications that you would be interested in. So if it's.
Yeah. The looks of it and then the design of it.
And then if there's a particular function of it, then sure, you can cover that as well.
Apply for
2
2 different patents.
different patents.
Okay.
Right, they're all distinct patents. All right, so for patent, you file your application, you get 20 years, right, for disclosing your invention to the public. Once you get a patent, yeah, it's 20 years from the date you file the application. For design, I think it's now 15. They just changed it to 15 years for design application, and that's for. So once you file your application, that starts the date. Now, the important thing to remember for patent applications is we used to be a first to invent system, now we're first to file system. So it's very important that once you have some idea, you want to if you're going to file a patent on it, you got to do it as soon as possible. You want to be the first one in the door to do it. A number of reasons. Our patent system in the U.S. will give you 1 year by the time you disclose your invention to someone, you have 1 year in order to file that application. If you go past the 1 year in the U.S., then you cannot get a patent on it. You've barred yourself from getting a patent application. That's in the U.S. If you want to get a patent in a foreign country, then most foreign countries, if not all of them, there is no 12-month period. Once you disclose it, you're done. You can't file for a patent application in that country. All right? So it's very important that you do not disclose your invention to the general public. You don't put it up for sale. Don't blog about it on the internet. Don't discuss it with friends and whatever, because once it becomes public, you can be in serious issue, especially in a foreign country.
Is there any specific, like you have to have NDAs, people on that you
It's
non-disclosure agreements with, and you're
definitely
outside of that?
right.
Be in kind of
Definitely recommended. Right. Now, as we go through this further, you'll find that a patent application itself, a regular utility application, is not an easy thing to do. It's a complicated process. You have to have so much information there. You have something called claims, which are very specific to what your invention is, and I could speak about that in a little bit more. So it takes a lot of effort, a lot of energy, a lot of information to get your application ready. So let's say you're going to go to, all of a sudden you found out that you got invited to disclose your invention at the Las Vegas electronics show, and it's next week. You're going to be disclosing it, so what do you want to do? You want to get something in the office as soon as possible because you don't want people to see it, because then that's going to start your 1 year date, or it's going to prohibit you from going in a foreign country.
As long as you do the patent pending, you say, or you actually apply for the patent?
You have to apply for the patent. So once you apply for a patent, it's called patent pending.
Yeah.
All right. So what we have, so there's a formal application which takes you through the process. There's also an application called a provisional patent application. So the provisional patent application is a very quick, down and dirty, just a description of your invention basically, and you send it in the office. That secures your date. However, you have to keep in mind that what you disclose in that has to be very specific. You have to put as much information in as possible. All right, so I'm just kind of glancing over these. I'm not giving any details on these at this point, just giving you some information. So these are the type of applications you can have. So what you're going to do, you submit all your information, you send it over to the office, and you file your patent application. You file electronically, it's cheaper. Right? So what happens to your application? Assuming everything is proper, assuming you have all your claims in there and all your fees are paid and all the parts are proper, it goes, the application gets docketed to a patent examiner. Okay. Patent examiners, we have, I think, just north of 9,000 patent examiners in the office. 13,000-ish plus people total in the office, about 450-ish trademark examiners. We have about 90 patent examiners in Denver. So patent examiners, so you're going to get, your application's going to go to a specific docket, a specific area. All these 9,000 patent examiners are divided up into specific subgroups of examination. There's a mechanical group, there's an electrical group, there's a chemical group, there's a biotech group. And among, for example, the mechanical groups, you may have transportation, where people who work on cars, trains, car parts, automobiles, boats, things like that. You'll have aerospace. You may have farming equipment in one place. You may have something else. So depending on what your invention is, it'll get slotted into one of those dockets. And you'll go to a specific group of examiners, about 13, 14 of them that are specific to that type of docket, all right? And those examiners, that's all they do, is they do that specific type of area. So if you have a flower pot, it goes to class 119, it goes to 36, certain technology, art unit, about 13, well, there's about 20 examiners in that area that just look at flower pots, and that's all they do. All they do is they've been looking at flower pots for 20 years. So they know flower pots, all right? Move that up to something a lot more complicated, they know that stuff too. They've been working in it for years. So it'll go to an examiner. All examiners have engineering degrees. A lot came out of industry. Some came right out of college. They came into the office. And over time, they've grown. They've learned their technology more and more. So if they're new to the office, they're called junior patent examiners or just regular examiners. They report to a senior examiner or a supervisor who has many years in the office. After so many years, they go through a certain program to prove that they can sign off on their own work. And those examiners will become primary examiners, will know their technology, will have the authority to sign off on their own work. They've been there for 6, 7, 8 years. They've done about 150 patent inventions per year times whatever year. So you're looking up at 1,000 applications that these people have done in that specific technology. So when you file something, you can pretty much be sure that the examiner is going to know what your invention is, for the most part. Then again, this is a patent office. Inventions sometimes are new. Sometimes we see things we've never seen before, and we don't know where to put it. So we try our best to give it with a patent examiner that may not, be aware of it. So they may be looking for some help to kind of understand what's going on. So we get that every now and then. So it goes to this patent examiner. He looks at your application, he or she looks at your application after about a year or so, after all of our backlogs, which are going down. And what they're going to do is they're going to read what your claims are, what defines your invention, and they're going to go look for it. They're going to see if it's been published anywhere. They're going to look at prior patents. They're going to look at publications. They're going to look at their digest. They're going to look at newspaper articles that are specific to their, or periodicals that are specific to their area. They're going to go on the internet. They're going to look at blogs. They're going to search everything to see if that idea has been out there before. And rest assured, they're going to find something that's going to be close to what you have. Most applications that are filed are actually, the first go-around, are actually rejected by the examiners. Usually they'll find something, typically something wrong with the application. That's not a bad thing if you have a patent attorney. That kind of gives you that's advantageous for you because you don't want to file something that's so specific that leaves leaves a lot of area for people to invent around you. So if you invent a flower pot that's a certain shape, a certain size with specific holes in it, and so much, you give it so much detail in your claims that someone just has to invent a flower pot as opposed to having 3 holes, having 5 holes on the bottom of it. If you claimed your flower pot has 3 holes, they just have to get something else to get around it. So what the idea is a claim to write your claim so they're broad enough. So it may get rejected the first time, and the examiner will find something on it saying, here's the closest relevant information we have on your invention. And what that does is that then allows you to see what's out there, to see what the area, the field is of what all exists, and then you can refine your claims, get them a little bit more specifically, just so they get around the best art out there. So next time it goes around, the examiner will say, hey, you got it, I can't find anything else on it, and you get your patent on it, and you got a nice broad patent that just gets around what's out there, but is not too narrow that it doesn't, someone else doesn't come and get it. So the process, you file an application, you get it, the examiner looks at it, they'll send you what's called an office action, telling you what the details of what may be wrong with that application. Sometimes there might be nothing. 99% of the time, there probably is something going to be wrong with it. They'll find something. They'll give you an opportunity to correct it. So you'll come back on an amendment, and you'll get a chance to correct the application. And hopefully at that point, prosecution closes. That's your last opportunity you can make another change after that. If the second time comes around, it's not quite right, you get one more shot. That kind of closes prosecution, gives one more shot to come in and correct it. If you don't get everything corrected at that point, you can't get an application. What you have to do is pay another filing fee to get those 2 more bites at the apple for that application. All right, so you file it, you get an action, or they may find it's patentable at that point. You change whatever needs to be done, you fix whatever needs to be done. The examiner looks at it again, makes a decision based on that, and after that point, it goes to either you have to file again, or you may actually get something, a patent based on that. All right, so if you have questions, feel free to ask, because I'm, just kind of, there's different.
So when you get to that stage that you get the final action, what does that mean?
So final action means this is our final decision on this particular case. You've amended those claims. You added, let's say we found a flower pot with 5 holes. Let's say these holes are not very distinct from each other. If it's 3 holes is completely different than 5 holes for whatever reason. So we find something with 5 holes, with 5 holes. This isn't a good example. You claimed that it has at least 3 holes. We found a flower pot with 3 holes. You go, oh, geez, yeah, I claimed at least 3 holes, but mine really works good with 5 holes. So I'm going to change it to 5 holes. So we do that. We say, okay, you got around that patent, that previous thing we found that has 3 holes. Now it has 5 holes. So we're going to take another look at it. If we find nothing else on it, we're going to issue it. If we do find something else on it, we say, well, here's another one that has 5 holes, or it's obvious to make it 5 holes. Therefore, that's our final decision on that. So basically, it's a final rejection is you get a first action to make some corrections. After you make those corrections, you get a second action, which is this is the last time we're going to allow you to make corrections. So in response to that, you make the corrections. If they're not done, you can either appeal the decision at that point, or you can file a case and continue to prosecute it by refiling it. Does that make sense?
Yeah.
So
there is a second action. So, like in my situation, I received the first action.
Right.
I didn't receive the second action, but I got a final action. So
The second action is your final action. A first action and a final action.
So okay.
And then the final action may say you either have to do A, B, and C, or do it, and you'll get a patent. If you don't, you won't. Or it'll say, we still have something on this. I don't know what to tell you, and then you have a chance to come in and still make some corrections, but we're not going to examine that case again.
Okay.
So the second time you come around, we'll consider it, but we're not going to. Unless it's perfect, we're not going to do anything with it at that point. Yes.
How much of a percentage of change to your invention does someone have to make to get around your patent? Is it like a 10% change? Or
No. It's how much you have to.
any change?
You can change when you change your application.
No, that's not what I mean.
Right.
I get a patent,
Yeah.
and somebody wants to get around my patent.
Okay. So it has to be. So patents are based on novelty and obviousness.
Say that again?
Novelty and obviousness. So depending if you claim a flower pot with 3 holes, you described this flower pot that has all these features to it. But the most important part of that is that it has 3 holes on the bottom, because 3 holes does this magical thing, whatever that is. All right. So you claim not that the flower pot has all these other things, but that it has 3 holes. If you want to, if we find a flower pot with 3 holes, you claiming a flower pot with 3 holes, we find a flower pot 3 holes. That's novelty. We have your invention, as you claimed. Okay, the other thing, if we find a flower pot with 2 holes, there's what we consider is whether it's obvious to add a 3rd hole. So there is this obviousness type factor. And this is where it becomes very subjective. So what's obvious? We look to see whether there's a motive, we have one reference we have one patent, a prior patent that says here's something with 2 holes. We have something else that says it's a good idea to put 3 holes in something for drainage, for a pipe or whatever. We may look at that and say, well, that second patent teaches us that 3 holes is good for this magical reason. It's obvious to apply it to a flower pot. Okay? So whether someone can get around your patent is whether what they're proposing to change is a non-obvious feature. So if they add something that's not obvious to change what you already have. So there is no percentage, it's just how different is it?
And so you rely on the examiner to make the that particular call.
Yeah, so the examiner makes the first call. You may not agree with it. You can appeal it, you can argue it. Yes?
In terms of getting a new patent on, case of obvious or whatever, so, if there's something out there with 2 and you can find a reason to modify it to make it 3, yeah, you're not gonna get a patent on it. But what if you have the patent for 2 holes, and then a rival company comes out with 3 holes, which is an obvious variant of your 2-hole design? Are you able to litigate against them because that's just an obvious variant of what I have patented? You are? Is that?
I don't work that side of it. I would,
I would imagine that because for publication, you could submit the prior art, right?
it would, so it would go to court, yeah. So you could either file a re-exam. So yes, you can. If you feel it's an obvious variation, you can have, let's say if they filed a patent on it, you can have that re-examined. You can take it to, you can go have it litigated, saying this is an obvious variation, and if a judge agrees with you, then sure.
I have a question about appeal. Appeal if your patent application has been denied by an examiner.
Yes.
What's the process for appeal and what are your rights?
Okay, so once an application's finally rejected, you have a final denial, final rejection of your application, then you can appeal it to the Board of Patent and Trademark Appeals. It goes to 3 judges, and all 3 of them get together and they look at both sides and determine, whether the examiner's right or you're right. So what happens is you file a notice of appeal at that time. You let the office know that you're going to appeal this decision. Then you write what's called an appeal brief. You give your reasons why you feel the rejection's improper, why you think it's patentable. The examiner, in response, will write a final answer to your brief, answering why they feel. They can either say, okay, I agree with you, or they'll say, no, I still don't agree with you because of these reasons. And they'll provide a reasoning why they think their rejection is proper. You have the last chance to comment on that. Those 2 documents go up to the Board of Patent Appeals. They look at it, and they make a decision based on that.
Is that all done by letter, or do you do it in person?
That's done by letter. You do have an opportunity to come in and have an oral hearing to state your case, but all of it has to be in writing.
I had a situation where the examiner who denied the patent also sat in the meeting and biased the thinking of the other examiners. Is that allowed?
During an appeal or a pre-appeal conference?
He was part of the group of 3 in the appeal.
Okay, so there's something that's called a pre-appeal conference. So before we take something to appeal, before you go to appeal, what we do is usually a supervisor, an examiner that has some time in that specific area, and the examiner who worked on a case will all get together and decide whether they should go forward once you file your appeal brief, or you give some brief reasons why you don't think the rejection's proper. A first cut goes to those 3 people. They take a look at it, and they're going to determine whether the office will continue and take that case to appeal. All right, so it goes between the supervisor, usually the supervisor, the examiner, and a senior examiner will all look at that and make that decision. That's probably what you're involved with, because typically, once the office decides from that point to take it to appeal, then you'll write your formal, we'll let you know, you'll write your formal appeal brief, we'll write the formal examiner's answer, and it'll go to 3 judges. So an examiner can come and watch that, but they can't participate in that hearing. All right, so what you're probably going down, you're probably before the actual formal appeal.
It's a little more active than that, and that worries me.
I think maybe,
Yeah.
when did they start that pre-appeal?
Pre-appeal, that's been going on for about 7, 8 years, at least, a while. I can't tell you exactly. No, applicant doesn't, not at all. The applicant in a pre-appeal conference, the applicant can write, I think it's a 5-page, it's a very short set of arguments that they're saying, the office shouldn't take this to appeal because of these reasons. Some very short factual reasons. It's not, the rejection is not proper for these reasons. Okay, it's hard to say without looking. But typically up at the board, patent and trial, the patent board, the appeal board, the examiners are not involved in that. They write an examiner's answer, and that's the last say they have. They can go and watch it unless the members want to, for some reason, ask them questions, which I don't know of ever happening, not that it hasn't, but.
I would fire the examiner. But I had a good experience too, where one of my patents went through with no office action.
Okay,
It was granted.
so. Yes?
Kind of a different thought process altogether. From the things that are patented, do you know what the percentages actually go to the product and actually become a business? Because you have a great idea, but you don't have a business. Yeah.
So and that's a great question, and I wish we knew that. I know back, and I'm talking back in the 1980s, there were some statistics going around that was like 70% of the applications became patents. 30% of those, roughly speaking, were actually marketed, and a very small percentage of that 30% actually were successful in a marketplace. That was way back then. What it is now, I'd love to.
You're saying 5 or 10% of things, it's kind of like
This was back in the 80s, so things were a little bit different back then.
baseball. Baseball,
Yeah,
how many people are drafted, and only 5% of the players.
yeah, but so patents have gotten a lot more expensive to prosecute now, so people have a lot more vested interest in them. So I would suspect it'd be higher than that.
In the Rocky Mountain Inventors Association, been involved for years, but what we say is that only 2% of those things that are patented make it to market, and only half of those make enough money to pay for the patent. And I think that's probably pretty good.
Well, what it costs to prosecute a patent anymore? It's quite possible.
Your numbers are in line with Shark Tank, by the way.
Are they? All right.
30% that apply.
They're taking stats from the 80s.
30% that actually make it only end up on TV. 30% of those on TV actually get deals on TV. Only 3% of those get actual deals that are done.
Right.
And about 80% of those are not the deals that were made on TV.
Although not enough of those.
Yeah.
I mean, one observation I would make is that universities and communities are doing a lot more to sort of open up their, portfolios to the community to allow them to look at those technologies and
right.
products in the market for a lot of reasons.
And some companies just, their portfolio, the number of patents,
Right.
whether they do anything with it or not, it's just, that's,
And a lot of the vendors think they might patent something, but they don't have an interest in starting a business. So they're always looking to license, that's a lot of, we get it,
right.
we tell people that the odds of that are way less. I mean, your odds of securing a good licensing deal are probably about 1 in 200. If you do the entrepreneurial route, you probably have a 2 in 10 chance of making it. So, your odds are just better if you swallow the fact that you got to start a business. At least at first, and build it into something, and then sell it. And that's Glenn did that on one of his products. He sold to his major customer, right?
Question,
Hmm?
if you have a utility patent and then you think you could also get a design patent, is it too late? You've already got utility.
You want to file anything you can before something is published. Before it's published. So you can file a utility application. And you don't, well, actually, in the U.S., to claim benefit of that date. So you file let's say you file a utility application. You want to file your design application before that utility patent publishes. And if you do that, you'll get the benefit of that first date that you filed that utility application. Okay, if you wait till your application is patented and then file a design application, yes, you have, assuming it 1 year hasn't passed from when you first disclosed it at all. You can do that, but then you can't claim priority of that earlier date. You can't say my first date of this invention goes way back here. It goes to where you just file that second application. It could be yeah. Exactly.
How, I understand that the USPTO is working a lot more with China and their IP, government agency or whatever,
Mhm.
that they're being a lot more, willing to work with, you guys in terms of carrying patents over. But they've opened it up, from what I understand, like significantly.
Are you talking about getting patents in China or controlling what China?
Where, since I've applied here in the US, I'm gonna apply in China.
Yeah.
Okay.
China does not have a grace period, so if you apply in the US and your application is published, like Mike said, you're done. So
Right.
if you want to apply through the International Patent Cooperation Treaty, then you can use that international registration to hold your priority date and then apply to different countries, including the United States. So you can do that when you file your US patent, right? So I don't know, the one question I have, but I don't know the answer to, is does that work for provisional? If you file a provisional and then file a PCT, does it go back to what we call priority date?
It goes back to the provisional, yes.
I didn't hear that.
If you file a provisional patent, I was asking when you file your PCT, your Patent Cooperation Treaty filing for your utility patent, whether or not that relates back to the priority date for your provisional. And the answer
Yeah, PCT can claim priority back to the provisional, right.
is awesome.
Yeah.
That's great.
Well, does the foreign patent that we didn't apply for, if you have a U.S. patent pending, and somebody in China says, oh, I like that idea, and they want to make it, what happens?
Protection is only good in the country that you have the patent. So if you didn't get a patent in China, they can go ahead and market it and do whatever. They can make it and use it. They just cannot import it into the U.S. They can't import it into a country that has that patent.
Okay. And how big of a deal is it to get a patent in foreign countries? You have to get one in each country?
How much money do you got? All right, so that's, hang on a second. So there's 100, I would say north of 150 countries that have patent offices. So you can go individually in each one of those countries and you can just drain your bank account as fast as you can think. So there's a way to go to a number of countries, well, let me back off. In order to do that, you have to file an application and follow each of those rules in each of those countries to do that. Not only pay the fees, you have to follow those specific rules. There's a little quicker way to do it, or an easier way, that you can file a single application. It's through the Patent Cooperation Treaty. It's called a PCT. It's So that is an international application. That sets you up to file, sets you up for a specific format. What it does is you file that application, it gets an international examination that's very generic to all the countries. It gets a search, you get a search report, you get a basic determination of whether something is patentable or not in a general sense. That gives you up to, from the date you first disclose your invention, that gives you up to 30 months to decide what to do. So at that 30-month point, what you need to do then is you have to go take that application and formalize it in each of the countries you want to go to. Okay, so if you wanted it to be effective in China and Japan and Europe or any of the European countries, you have to formally pay those fees and nationalize it in those applications. At that point, it gets another examination in most of those countries. Some countries take the examination of the PCT on its face. Other countries do their own examination. But the advantage of it is you're saving yourself a little bit of money because the format is the same going to all those countries. You don't have to deal with individual formats. And it gives you time to determine whether it's even worthwhile doing it, as opposed to going to each country, which you had to do within 1 year from filing in the U.S.
So if you get it patented in a patent pending here, and you say, well, I'd like to market this also in Great Britain or France, I can do that
Yes.
regardless, but I think the patent
Right.
over there.
Yeah, and you have 1 year to do it from when you file it in the U.S. Paris Convention law gives you 1 year to file it in each of those countries if you want to do it separately. It also gives you 1 year. So if you want to go in France, you file it in the U.S., you have 1 year to go to each of those countries that file their application to keep the benefit that you have in the U.S. Keep that date, that earliest date in the U.S. Yeah, individually, if you want, or one year to go to file your PCT. If you do that, then you have another 20, okay, 30 months from when you first filed your application.
So if you have a product, and let's say I don't want to sell it over there, but I want to license it to a company in France, China, and Japan, I can do that, and then they would do it, and then I would get my licensing percentage of it, I would say.
Which you
I-
can file in those countries. You have to file and file.
It depends what kind of agreement with you, what you have and how honest they are and how, yeah. So, yeah, most of them, they require you to be the inventor. So if they were to file your invention, they're supposed to be identifying you as the inventor. You know,
PCT is from the time you file it, you have 30 months.
for a PCT, you have to file a PCT 12 months from the date you file it in the U.S. or any country. You have either one. Either one. You have 12 months to file that. And then from that date, you get an additional 18 months. Thank you for doing the math for me. To equal 30 months total from the first filed your invention to when that, you have to make decisions at the end of that PCT. Yes, from the earliest date you filed your first application.
That's the decision to go ahead and file for patent in those individual.
Yeah. So what a PCT does, it gives you 18 months to make that decision to spend all that money to go in all those countries. A PCT is probably around $1,500, I want to say, in the area. It's been a long time since I've. Yeah, once you go into the national countries, then you're paying their filing fees and all of those fees. And from what I understand, it could be very expensive.
To designate more countries, does that cost?
It doesn't cost extra to designate countries when you file your PCT. Right.
Blanket state?
Yeah, you can just check all the boxes you want, and then you can decide what you want to do after that.
And we file a PCT through the USPTO?
Yes. It's based on, yeah, right, it's based on your nationality.
The benefit is that they do an international search and an international preliminary examination. So they'll give you an opinion on patentability, and you can amend. Sure.
Yeah.
And the countries you go into will look at that. So if you get favorable opinions, you can feel better about your patent potential.
You mentioned utility, patent, and trademark, copyright, the different
Mhm.
things. The PCT is only for 3 areas of patents.
Utility, and now we started designs. Yeah, yeah. Yeah. Right, and I don't know anything about those other than they exist. So I don't know if they're out the door or not.
On the trademark side, you have the GRID protocol, which is very similar to PCT, the Patent Corporation Treaty, which allows you to file for an international registration, which similarly marks an international priority date, and then you can do the same thing. In terms of the time frame, I think it's a roughly analogous. It's less.
Just 6 months
It's six.
on designs and trademarks for international priority. So they cut it pretty tight.
It's only 6.
Yeah.
Yeah, I was just researching it because someone asked me about international designs.
But designs are
Yeah, yeah, it's all,
but they're relatively similar.
Time frame you just talked about, Roberto was saying that probably better to almost go to PCT first, you're at 30 months. Total,
Or you can file a provisional, I mean, that's also.
but you have no protection for PCT,
but,
if you apply here,
The risk is you gotta get a foreign technology export license, and you have to pay extra for that, so if you file in the US first, they do that automatically. If you file foreign first, you have to get a
you have to pay
technology export.
$200 and within,
Yeah, a couple hundred.
within 1 or 2 days, we can get you your license.
So,
so you're saying apply in the US, and then,
it's simple.
and then apply PCT.
I'm not, yeah.
Fairly short period of time to protect.
He's saying that. I'm not saying anything. You could, there's a number of different ways you can do it, and you need to decide.
It's, the US Patent Office gives you a deal because your filing fee is lower than their cost. So you're saving money. PCT filing fees are a lot higher. You're paying their cost, so we file PCT first, it's gonna cost you more. And most people that file US, they can like, see the commercial
Yeah.
potential is gonna be there for a year and then decide.
Okay. So, all right, so kind of, I'm going to take a couple minutes. I have some handouts on that back sheet that I'm going to go through, but this is the top 10 tips for suggestions when you're filing an application. So I was going to go through this fairly quickly, and a lot of these things might come up in some other stuff. Pardon? On that back chair there? Right there?
You guys, I'll
So there's some good information here, especially if you're new to patents. I'll get there. Don't steal my thunder. Oh, not including maintenance fees. All right. So first tip. The first tip is just understanding what you have. So we talked about the different types of intellectual property. And on one of the slides here, it talks about the advantages of utility, patents, designs, trade secrets, copyrights, and trademarks, and a little bit of information of what they are. So I'm not going to go through that again. So as an example, you can look at the smartphone and the different types of intellectual property on that smartphone. So the trademarks for an iPhone, for example, the term Apple, the term iPhone, things like that are all trademarks. People associate that. If you get an iPhone, you know what that's going to be. So that's that trademark. The different patents are the semiconductor circuits, the chemical compounds that go into the case, the battery, the antenna. There's probably, I think, over 1,000 patents on the iPhone alone. Copyrights, the software code, instruction manual, ringtones. So you can see all the different types of IP just from that one graphic.
So you're saying if you want the international, it says here that you have to apply before the public disclosure.
Yes.
So if you're applying for a provisional patent, you don't want to.
Okay, let me go to provisional patents real quick. So you know what type of patent. Hang on a second. Tip 2, know what kind of patent's right for you. So sometimes, design, whether it's design or utility or both. And then we're a first to file system. If you're looking for international protection, you must file before any disclosure. And if you want to file in the U.S. and you disclose it, you have 1 year to file your application. So only the U.S. gives you that opportunity. Once you disclose it, you have 1 year to decide to file it, and you're still protected, okay? However, if you're going to file internationally, if you want a patent in another country overseas, once you disclose it, you can't file for that application. So you have to make that decision. If you're going to be filing it in another country as well as the U.S., you want to file that application before you disclose it. If you're going to a trade show, if you're going to disclose it, if you sell it at a flea market, if you're going to talk about it on the internet, you want to file that application before you do that.
So if you're gonna have it manufactured in China, you wanna get it applied for first.
It would be a good idea. Yeah, I mean, then you get into non-disclosure agreements and whether they will, whether someone will abide by that, your faith in human nature and all of that stuff comes into play. Yes?
If you test marketing but not selling, is that disclosing it?
It could be. It could be. You always want to have something, and there's a number of attorneys here that'll,
There's confusion, and I had issues with clients this, because it always was called first sale doctrine, but really, it's any public disclosure. You don't need a sale, you don't need even an offer for sale. If you show it without confidential obligations, it's not. So the bar is very low.
and trust me, yeah.
We just casually shop.
You don't know how many times we find blogs or people on the internet describing their invention to someone else, and it's captured. They put it up on a website. You put something up on a website on the internet, and you think, oh, I made a mistake. You take it down. We're going to find it. There's a history of it. We'll find it. So we can see what that website was 2 years ago.
So if you do have everyone testing the product, sign a disclosure statement,
Right,
then
and
they're
you're doing it
doing
with, it's, the courts would call it experimental use exception, so everyone's under confidentiality, and they're technically testing it, and the important thing is here, you don't sell anything for money. And you the products out for testing, get them back, that's not a disclosure, you're fine. But if you sell something, and there's been cases like this, then the courts are gonna say, your testing's over, you implied it's done, you're sold,
All right. All right. So moving on, patent tip number 3, know the difference between a provisional application and a non-provisional application. So your non-provisional application is what's going to get you that patent. That has all the details, that has all the formalities in it, that has the claims in it, that has all of that stuff that gets you the patent. A provisional application is an application you can file to save your date. It's good for 1 year. After 1 year, it becomes abandoned, and that's it. So if you want to do a patent pending real quick, if you're going to disclose it, you want to provide that information, just get it in your foot in the door, so to speak. You can file a provisional application. They're like $65, I think, is a small entity or micro entity. We'll get into that in a second. It's very cheap. Right. It never publishes. Right. Yeah. Right. And yeah, and it gives you 1 year to file that final utility application that's going to get you your patent. But the important thing is, if you're going to file provisional, just you got to do some work to do that. You have to put as much information in there as you can. You have to be as descriptive as possible. And what you want to do is probably look at some patent applications. If you want to do this, you look at some patents that have issued. Go to Google Patents. Search your area, pull some patents up and look at it. See how the description of the patent goes. That's what you should be in your provisional. A good description of what your invention is, drawings to back it up if needed. As much information, too much information is not, there's nothing wrong with that. All right? Well, for the most part. That's a provisional application. You can put patent pending. You can have the year to decide what to do, whether you want to spend the money to file a regular utility application. Again, it's cheap for someone who's an independent inventor, small micro entity we call them. I think it's around $60 or $75 to file it. All right. patent tip number 4, conduct a thorough patent search. So once you decide to file a utility application, it's going to cost you some money. To file a regular application on your own, and we'll talk about this in a second, is from beginning to end to pay the issue fee is about $650 if you were to do it on your own. However, we'll get that into the last patent tip, number 10. So what does this do for you? Number one, you, by searching it yourself, by going out and searching your invention, you'll know what's out there. You'll know what's been done in the past. Like we said, a very small percentage of inventions actually get to the marketplace. You may say, well, I've never seen it. I've been to Walmart. I've been to Kmart. I've never seen this anywhere. This is new. You'll find that there's a whole subclass of articles or patents that are just like what you have. So it's good to do a prior art search, to go see what's out there, to see what you have, whether it's been invented before, how close are those other inventions, or whether it is actually new. What that does a number of things for you. I'm skipping ahead. You might, from that, you may look at some other patents that come out, and you may see some different things that were done in those patents that you may say, hey, I can apply that to mine. So you can actually improve your invention before we even file it, just by seeing what else is done. You can make little tweaks to it and actually make it better just by seeing what's already been done out there. You see the trends in the field. Prior art is a term that we use for prior patents that we find, prior art and publications. So you see what's all relevant. And so eventually it helps you determine whether you want to file, whether it's worthwhile to file that patent application, whether it is you believe it's truly an invention that you want to file something on. All right? And you may find that there's 100 patents on a very similar thing, but you may not see any of them in the marketplace. You may wonder why. Is there some political reason or some other reason why these things aren't coming to the marketplace? For example, I was talking to a couple people. I used to work in firearms a long time ago, and there are a lot of patents with locks integrated into a weapon, into a handgun or whatnot, for safety. Do you see any of them in the market? Do you see any of them for sale? Nope. Why is it? There's some political pressures not to do it, so they don't do it. You can buy separate locks to add on to guns. So I'm going to talk about that. There's hundreds and hundreds and hundreds of inventions on locks for guns that are integrated into guns that you'll never see. So, great idea. Is it going to worth anything if you can't sell it? So that's conduct a search. And also what the search does is, so if you want to, if you're going to go to an attorney, the attorney will do the search for you. They'll charge you the money. They'll do the search. But wouldn't it be nice? It's very cheap to do. It's free to do. You can go to Google Patents and do the search. You can go to the Denver Public Library, for example. They have a patent assistance place there that will help you do the search. You can come to our office in Denver. We'll show you how to do the search. We'll provide the equipment where you can do the search to find out whether your patents, what's out there, whether it's worth even going that, whether it's worth going to an attorney and spending that money for them just to find that it's already been done before. So it's part of doing the legwork before you file that application. Patent tip 5, recognize and provide the proper parts needed for filing an application. Again, you want to go and look at patents in the field that you're in, look how they're written, look how they're organized, how they're described. When you file that application, you want to make sure everything is in there. You want to make sure it's correct. The worst thing you can do is file an application that's half the information in there that you needed to be in there. 2 years later, it finally gets to an examiner's desk. The examiner looks at it, gives you a rejection saying, I don't understand what this is. You didn't explain it well enough. All of a sudden, you spent 2 years, all that time, all that money, only to find out that you wasted 2 years of your time and you did it wrong, so you got to start over again. Hopefully it hasn't been published at that point. Okay? So a lot of labor. Our website, uspto.gov, provides a lot of information. There's directs you to a lot of YouTube videos on how to file an application, what's required, what are the different parts, and things like that. A lot of information on our website. Pay the correct fees. So we're the government, we're helpful. You have our regular patent fees, We have, they're called small entity patent fees, which are half of that price, half of the regular price. And we have what's called micro entity fees, which are a quarter of the regular price. Okay, so for example, if you were to file an application as a micro entity, and there are certain requirements that are identified here to be identified as a micro entity, $650 from beginning to end just to file the application, if you were to do it yourself. If you were a large entity, it'd be 4 times that to do that. So we do give discounts. Also, filing electronically, it's a whole lot cheaper to file electronically than it is to file it in paper. You can file electronically through our website. There's ways to do that. So you want to make sure you're paying all the correct fees. If you don't pay the correct fees up front, you may be hit with a surcharge later on for not paying the correct fees. So you want to make sure you do your homework on what the fees are. And a lot of our forms actually bring you through this. An electronic filing system actually identifies, if you mark things properly, it'll tell you what fees need to be paid. Patent tip 7, respond thoroughly and timely to all communications. This is a very formal process. It's a statutory process. You have 6 months in order to respond to an application. If we send out a rejection, you have 6 months to come back and give us a response. You have to address every concern we have. You have to mention every concern we have. However, although over 6 months, it's going to cost you if you go over 3 months. So 3 months, the first 3 months, you can respond for free. If you're going to respond in that 4th, 5th, or 6th month, it's going to cost you money. What we're trying to do is make that prosecution go quicker, go faster. It's fresher in the examiner's mind if you come back within 3 months than if you come back in 6 months. So there's a whole host of reasons why we do that. But statutory, if you go past 6 months and 1 day, your application is abandoned. You have to refile that application. We have nothing, there's nothing you can do about it on our part. It's a statutory law that you have to respond to it in 6 months. Number 8, consider using a patent attorney or patent agent. If I was to print out our patent manual, it'll probably be about this high. So it's a very, not that you can't do it yourself, many people have done it themselves. So if you do a lot of legwork, go onto our website, really do your homework, spend a lot of time doing a lot of research, it can be done. What it's going to come down to is the claims, which are something that are baffling to most people, most new examiners that come in. A claim is a 1-sentence description of what the specific important part of your invention is. Your whole car can be an invention. You invented a car, but really the key aspect of your invention is how the door opens. Maybe the door swings like this. You invented this whole car around this whole door that swings like this. So you're going to describe the entire car, how everything works, but you're going to claim, what your claim is going to be is a door that folds upwardly or something like that. But it's going to be much more wordy than that. And that's the most difficult part of filing an application. This is why attorneys make so much money. This is why they're worth their weight in paying some of these fees, because they know the process. You can cut down on that process. If you go to an attorney, you can cut down on the process by doing a lot of homework yourself. You can write up the description as best you can. That will take some billable hours, possibly off of an attorney, if they can accept what you wrote as your description. You can give it entirely to an attorney. From beginning to end, they'll do it. You can do as much work as you want, legwork as you want. And you can, I got to say that you can file it yourself. It's a very difficult process, though. So you got to do a lot of homework if you're going to do that. Our website has a lot of information on it. So something to consider. There are, based on your financial status, you can potentially get some pro bono help, some attorneys working for free. There's a way to do that. There's a place in Colorado called Mikasa. They have a website that you can sign up. What's required for you to get free help from an attorney is you have to have a certain minimum or certain maximum income and some other items that are on here. But they require you to do some legwork. They require you to go through a video to learn about the patent process so you know exactly what's going on. They require you to do some certain things, some certifications that you've done a lot of this stuff. So you come into it knowing something, and in turn, they will help you as much as they can. I don't think I have Mikasa on here, but that's the, if you go to our website, you can type in pro bono. It'll probably take you to the section where you click on, you'll see the map of the country, you click on the state you're from, and it'll give you the various places that will assist in those locations. And like Ed, there's a certificate, there's a training course you have to go through to complete. Patent tip number 9, avoid getting scammed. So this is inventors help submission places and things like that. Not that they're all bad, but some of them, we've had a lot of issues with them. We have on our website, there is a blog at our website that you can actually look at some of these and read some of the stories about some of these places. So we don't comment on them, we just provide the blog. So someone may have a bad experience, we put it in there. That corporation or whatever has the opportunity to respond to that. So you can kind of see a history. So it gives them the opportunity to respond, gives you the opportunity to write down, and then you can make a factual choice yourself or decision yourself whether you want to go with this particular place or not. And there's also things like you get, once you file a utility application, by the way, it's automatically published at 18 months. Unless for some reason you sign a form they say you don't want to file a foreign patent application. But whether you want to or not, it's going to be published at 18 months. And people see this, they find out who you are because your information is put on there. And you may start getting emails saying, patent office, we're the patent office, and to further do something, you need to pay us some more money. You'll get an email or something like that. Just keep in mind that we don't send emails to anybody regarding anything except training or whatnot. Okay, so just something to be very aware of. We have a nice, some good information on our website about things like that. And
I know somebody that went through that process with one of those companies, and of course, the whole time, like, wow, it's $1 million idea, the structure
yeah.
idea, the flash with money in front of her, and $30,000 later, she had a design patent.
There was back in the 80s, I don't know why I keep going back to the 80s, there was a company, yeah, that you'd file an application and they would put their own little design on it and they would file design applications. And the office eventually went after them and shut them down. But yeah, a lot of people lost their money just based on that. And then patent tip number 10, this is our website. It has, you go under patents, you click on any of these things, it has a whole lot of information for inventors. If you've never been through the process before, it'll give you a whole lot of information of what it's about, how to go through the process, what you need to do, whatever you're looking for is there. It has under attorneys, it has all our contact information. It might have that under inventors as well. We have a number of help. We have an independent inventors helpline. We have helplines for all different parts of the office that are identified in there, so whatever you need help with. So it's a whole lot of information in there. And so that's all 10. So I hope I've covered a good amount of what you're looking for. Like I said, we're here to help you, so I'm trying to make this so it's as much information as we can get to you.
Is this program available online so you can print it out bigger so you can read it?
We can get you a copy of it, yes. I can send it to Roger. I give you my glasses if that's why. Yes. Sure. I'll, if you want to get with Roger, I can send it to him, and Roger, if you can send it out to whoever needs it.
I might also mention, we offer search classes, we got one coming up in mid-February. You can check our site, it's at the Denver Public Library downtown. So, there's a lot of levels of search, from basic to east and west, and then east base, which is European,
Yeah, so I spent an hour going through this. Once a quarter, as Josh said, we're trying to do it once a quarter. We have our a seminar on Saturdays that go for about 8 hours, that go through this entire process.
When you have that?
I don't know when the next one is yet. It'll probably be in a couple months, but yeah, last one was about a month ago. Yeah, yeah. Yeah, yeah. So we'll go through the entire process there, which is very helpful. And we also provide, we're trying to provide as much information. For example, we were going to try and do a search thing, or maybe have an on-site help, possibly. Maybe some trademark information on a periodic basis.
It says it's a patent attorney. And I guess I would ask you want to do this, but a patent attorney, to put that on their business card, has to go through a process with patent.
Yes, they have to be. So there's patent attorneys and patent agents. So they have to go through a registration process. They have to take a test in order to be certified to be able to practice before the office. So there's patent agents who are not attorneys but can practice before the office. And there's patent attorneys that can also practice before the office. They just can't litigate later on. They can.
Is the only litigation ability to litigate before the board is the only difference between an agent and an attorney, or are there more?
Before the board, I know in court. I don't know before the. Yeah, I think an agent can go before the board. Yeah, yeah.
Okay, so administrative appeals, but not petitions and stuff like that.
No, they can do petitions. They just can't go to a federal circuit or an outside patent office. Right, right.
So if somebody infringes on your patent, that's where you get the patent attorney.
Yeah.
And then licensing contracts, all that stuff.
Right. And then, so our office provides, we have the search capability there. We have, Denver Public Library has one search station. We have 4. If they're free to come and use, you sign up for them and you get free time. We'll help you as much as we can. We can't give you any advice on what to search, but we can show you how to search. We have what's called so I said we had 9,000 plus examiners. At least 3,000 of those examiners are teleworking. They work throughout the country. They don't work in any particular office. They work out of their home. If you want to interview any of those, or if you have an examiner, by the way, if you file an application, chances are of getting an examiner in Denver are very remote. Like I said, there's only 100 patent examiners in Denver. They're across the board of all the technologies. So it may be that your application hits one of these examiners here. And if it does, you have the opportunity to come during your prosecution. If you get that first office action, you can go and talk to that examiner. Say, hey, what can I do? What do you suggest? If they're not in this office, we have a space where you can interview the examiner on a big 60-inch TV to interview the examiner wherever they are in the country. Face-to-face, talk to them, and get some advice that way. That should be one of the patent tips. Talk to the patent examiner. Interview a patent examiner. Do an interview. Once you get your first office action, where are they coming from? What do they know? What haven't they told you? What do they suggest? What do they see? They know the art. They've been there lots of years. They might know, hey, if we only did this, if we only did that, it's a better direction to go.
How long do you need to file for that, or how long notice?
Well, it depends on a patent examiner. So don't wait for your last 2 days before your 3 months is up or your 6 months is up to do that. Give them a couple weeks notice. So some of them, if it's around vacation time, they may not be around, but they do take vacation. They have certain times they have to work.
So interesting, for some of the people, I don't, obviously, but, so you never actually sell a patent to a company, you only license the patent to the company. The assignee, the inventor stays always the inventor.
Oh, yeah.
But there's an assignee, so you can assign it.
You can assign it.
So I guess, yeah,
Inventor always is a sale.
you're always the inventor.
Assignment is a sale? I understood the assignment was just an assignment.
Well, that's,
It's whether you get money up front or continually get money. I don't know.
a lot of times people will assign maybe part of the rights, not all of them. So that's how it kind of gets split up.
And then
All right.
I understood that you never sell a patent because, well, I guess it's because the inventor never changes.
Right.
Inventor will always stay the same.
Yeah, inventorship will never change. You're always the inventor.
Owner by default at the start, but certainly if you're working for a company, the company's the owner.
If Apple throws that new thing out there, you can always say, I was the inventor, look at the patent. That's mine that I just gave, gave to Apple, or Google, or
So
whatnot.
the assignee, whoever that is, if the inventor goes and uses it in the public space, assignee trumps the inventor, and therefore the assignment can sue the inventor.
Well, it depends what agreement you have for the assignment.
You can assign any way you want, you just have to show an exchange of value.
The government typically assigns all their inventions to the general public with the exclusive right to make and use it on their own.
Yeah, and we've got that coming up, we've got a bunch of government stuff coming, but, SBIRs, government grants and stuff, they can be a good deal if you can get into a private. The government will fund your seed research, and, all you have to do is grant them a license, a perpetual license for their use. You own the patent, and you can make money off all their non-developed uses. Sometimes people do pretty well on that, but the grants that's competitive.
Mhm. Yeah.
The government lays out, we will pay for technology development in certain areas. And so you have to fit into one of these slots. But I've had a few clients
Yeah, we have Department of Energy and NASA are two big.
make out against things, so it's another option.
So we're downtown Denver, Stout Street, 19th and Stout Street. We're open 8:30 to 5. So if you have any questions or want some information, we can sit down and talk to you. Like you said, we can't give you any advice on what to do, but we can go over the process or any questions you have. There's only about 3 or 4 of us in the office managers at any one time. So you can come in, it's good if you call ahead of time to schedule something. Otherwise, if you show up, we'll find someone to come and give you help eventually.
But you have a little appeals court in the other.
We have a little courtroom.
Is that open to the public at all?
If it's a public hearing, we can publicize it. Yeah, we can, there's only 2 chairs in the back, but we have projected it into another room where you can sit in another room and watch the hearings if there's a number of people. If it's something that that's public.
People could watch and appeal and
Yeah.
look at and see what the exchange is like.
Today we had our first post management. But we had one of our judges participate.
Mhm.
You may have said it, but what's the backlog from the moment that you apply?
And so it depends on the technology. It's gone down from what it's been. I think, on average, what is it? Is it 10 months, I think, the first action on average? But you can be in a technology that's really new, really growing. We haven't hired enough people in there, and it could be 2 years before you get a first action. It could be a technology where it's not very active, and you may get an action within a couple months from when you file the application. But we've hired 1,000 to 1,500 examiners for the last, I want to say, 7 or 8 years. And this is the first year we've just stopped the big hiring. Yeah, no, actually one of the reasons we came out here is just because we've hired so many people from Virginia, Pennsylvania, from college students, Virginia Tech, UVA, Penn State. I think we kind of emptied those schools out of all our engineers, pretty much. Right. Yeah, and it was nice out here. So it was all industry we hired out here. We hired very few. I think we hired one or two people from college, directly out of college. Most of the 90 folks here were hired from industry, from the areas they work in, or prior patent experience.
And one thing, because I'm in a business school right now, and one thing I found was very helpful, as we've gone through, talked about all these things, is there's a book out there called Business Model Generation Canvas, BMG Canvas. And if you get that book, there's a
things to look at. Yeah, a lot of considerations to take into account.
But like you said, it's very important to test your value proposition in the marketplace, right? So you have to figure it out.
Now, is it true that the U.S. Patent Office will not entertain nor accept any patents for like anti-gravity, perpetual motion, and I think those are the two.
You have to prove that it works and that it's reproducible.
They like it to watch it.
So if somebody was actually able to prove it, you guys would actually take it? Because I understood that the perpetual motion was one that you guys wouldn't even entertain.
Yeah, as long as, you can file one on, we have to examine it. How to stop a tornado, cold fusion, a couple other crazy things we get a lot of applications on. And there's a lot of, so, it has to be reproducible. You have to be able to show us that you can hit that tornado, you know where it's gonna go to. Just things like that. I mean, so we ask a lot of questions and things like that.
But I mean, as the applicant, I mean, if it's something that's, you can't really pull off, you're never gonna commercialize it.
Yeah, yeah.
So why would you waste your time? You know?
Yeah.
Um,
Also invented, we had a patent that we do for kids. And it was from the 60s, how to fold a paper airplane, or how to make a paper airplane. Nice to have a patent on it, great. Hang it on the wall. You already gave it away, you know how to fold it. So the patent's already published, it's expired now, but so we have kids come in every now and then on Bring Your Kids to Work Day, and they see whether their patent's good, whether they can understand the description of it to fold a paper airplane. It's a fairly complicated airplane, but, so.
Do you guys have any, as U.S. patent people that see a lot of patents, you guys have anything that you see as a patent or that's even well expired that nowadays people don't think anything of, like toilet paper was patented in like 1928 or something like
Mhm.
that. That's one of the things I keep on my desktop is like, it reminds me, people don't think about toilet paper being something that would be patented, but it actually was.
Yeah,
Do you guys have
the
anything like that?
founder of the Girl Scouts kind of patented I think it was a paper waste basket.
Yeah.
So how do you pull, it's actually, if you think about it, I don't know if you've ever seen where you can pull paper and make a cup and drink out of it. It's the same principle, just larger for a child.
We use that one also when I bring the kids to work.
As a sort of a paper cup thing, so you're kind of drinking out of the trash. That was actually her invention, and it's very, very simple, right? So.
Yeah, so you can see all the basic. The
Do you have any?
right airplane, the right flyer. All I can talk about is weapons. The 1911 revolver, first revolver. Yeah.
Interesting stuff.
They were running with the snowman. Remember the snowman?
Yeah, well, that was it.
Someone patented the process of using a laser pointer
For
entertain a cat.
Liz Shaw, yes.
Yeah,
I know the Examiner.
Yeah,
A stick.
yeah.
So, yeah, we could talk about some of the ones that are questionable. The dog toy, yeah.
Well, it just has to be novel and obvious, so it doesn't mean it has to make sense or.
And there is not always a correlation between patent and business success, right? Because sometimes you have business success, don't have a patent. Sometimes you have a patent, but you don't have a business success.
Yeah, sometimes
So
people
not
just
always,
want a patent just because they have something to hang up on the wall. Really useless, but,
sometimes, yeah.
or not, well, useless to some extent. Fairly useless, let's say. Yeah, you had something else?
No, I was just gonna say, you had a really good point with these slides. A good way to use all this, prior art searching is to find stuff for solutions to problems that you have. So if you wanna figure out how to do stained glass more easily, you can get on the prior art search and type it in and learn your techniques to do things. Cause I'm sure you're all builders and makers as well, so it's just, something that people don't really think about is they put in that patent and disclose it to the world exactly how to build it, exactly why it works, what the other art is out there that why is this better. So
pay maintenance fees, and the maintenance fees goes up and up, you know, as you come closer to the 20 years, so not all patent, you have to wait 20 years eventually to use the same application, because they've been abandoned, so.
Yeah, if they don't pay their maintenance fee,
They
right?
pay the maintenance fees, so.
They'll go
yeah.
down, right?
What are the maintenance fees, so you just ballpark?
Yeah, at 11 years, right?
So
4, 7, and 8, 11,
11,
right?
and they like double each time.
They double.
Fees.
So they,
For
pretty high.
yeah, for a small entity, I just paid one for a small entity at the 11 year was $3,700 to maintain a patent through the 20, up to the 20 years, so
Okay.
from the 11 years to the 20 years, it's expensive.
$4,000.
Yeah, but
That's the cheap one.
that's the small entity, that's for small entity, so yeah.
And then for the 0, well, of course, you know, 30,
The
1,300 to get it through.
The
and
first,
then-
the first is about, I think the first
It's
is
worth
about
putting over a
the,
micro.
for the small entity, for the, to bring it to the 7 years is $800.
Eighty,
880, right, yes, right.
that's the 3 year.
This is 3 years, right?
So here's something else that's interesting, sorry to interrupt, but is it also a fact that if you find somebody claiming that they have a patented product on a packaging, and they do not have a patent on it, that you guys will actually fine them? Sue them so I read an article that said that it's illegal to claim that you have patent.
That I don't know.
I know that there's a government agency, I read about it, and where it's filed.
Statute, I mean, there's a statute.
With our enforcement
Yeah, it's an
division
enforcement-
will go,
Enforcement, yes,
it's not enforcement, it's,
but it's not really
And the other thing,
enforcement, or it would be a challenge.
I know Dixie
I-
Duck got caught on, I mean, when you get your patent, put your patent on your product, and then patent has its life, it's expired, you're supposed to pull the patent off the product. And they left it,
oh,
and, they were getting fined,
Yeah.
so they got fined from someone.
yeah.
I don't know if it's our office or, I don't know.
Usually you put the patent number as a patent, right?
Yeah.
And then you can always search the patent number to see if the patent is still in force, still alive.
But it's illegal to put it on, if that patent's expired, then you
Well,
can't
if
put it on.
it's expired, then you don't pay the maintenance fees.
Yeah, but it's, but
You're
you're
supposed to take the patent number off.
You
Yeah.
can charge.
When it comes to writing up an NDA, can it be as simple as, you know, I, Adam Zimmer, will not take the invention of John Smith that you disclosed about blah, blah, blah?
The office
I mean,
doesn't,
like, how complex does an NDA have to be effective?
Could be quite complex.
I know this is very good.
isn't there a website that does that for $10?
Pages, no matter what, people have a one pager, it's just, the bit about confidentiality can be not that long. There's a lot of ancillary issues, like the purpose you're disclosing, what the person's doing with it. And then if they contribute to the idea, you have to verify, okay, who owns what? And what are our rights? And, so there's a lot of kind of things around it,
For $65, you can file a provisional application, and so there's a whole lot of money.
Trade secret is, theoretically good forever. So you would say, if you're confidentially, like, all the agreements never end. Of course, not necessarily gonna hold that, but, if someone did steal your idea that they breached that, you can go against them. If they try to file a patent, you can say, you make a declaration to the patent office, I am the inventor, or you lie on your declaration, so you can get their patent.
So a trade secret, those things, a trade secret is not actually a patentable thing, that is.
It could be your
It could be, but you decide
It's,
not.
Well, it's no longer a trade
It's very
secret.
fragile legal existence, if you make any public disclosure requirement.
Yeah, so if it's something that can't be reversed engineered, I guess, is a good thing for a,
So a trade secret would be like
Kentucky Fried Chicken, a recipe for, it could be a formula, it could be a software,
Very, very complex process. No one can really.
it could be a,
So the idea with the trade secret then is you might want to patent the trade secret? Or do you just?
it could be a way to generate a customer list.
Sure.
I mean,
It's again.
if you patent a trade secret, it's no longer a trade secret,
Right.
because we're gonna publish it.
Loses its trade secret.
So you want to keep it as just a trade secret and never patent?
It's
You
again.
can, but,
it's
it
a
could
risk.
get breached easily, reverse engineered, or
Right.
anything like
Or
that.
where do you apply for trade secret?
You don't.
It's just a matter of you don't see.
Eagle Claw here in Denver, they invented that machine back in like the 40s, that you feed wire in one end and a barb hook comes out the other. Trade secret. They never have patented that machine because they didn't want to reveal it to the
So no one knows what happens in the machine, because they can't see it.
Right. And the operators, they don't get to see it. It's in a box. I mean, it's just literally goes in one end and spits hooks out the other side.
Yeah, so that comes under state law, if I'm not correct. Comes under, it's under state law. So if you protect it a certain way, as long as you do certain things to make sure it's protected, if someone steals it, you can go after them.
So if it is a trade secret and they do reverse engineer it, and they come out with it then in the state.
If there, well, there's, yeah,
So that's the risk.
you have to protect it in some form.
Reverse engineer easily is a bad trade secret.
So you should patent it or see if you can get it.
Yeah. But some things it's not worth, for example, Coca-Cola, if they patented their original recipe for Coca-Cola, other companies may have, after 20 years or after 17 years.
Yeah, it'd be long expired.
It would be long expired, they would be out of business by now, because everyone
So
knows
it's just
it.
the fact that it's secret and nobody's been able to reverse engineer it, they just.
Right.
Oh, I find that hard to believe. They chemically.
People think they have, and you can try some of it and maybe very close.
Reality, because they obviously don't make Coke today the way they did years ago.
Sorry, the old Coke, the new Coke, the
Yeah,
classic Coke.
they didn't make it with corn
Yeah,
syrup
yeah.
100 years ago.
But even if you find out the do the molecular analysis, you can't know the order, the way. There's a lot of
Time,
things
temperature,
that-
sequence.
Time is the process that is really the secret. So many steps, so many variables that are, that without those, you cannot come up with the same product, so.
A lot of it's, material engineering, a lot of material engineering is for that reason.
Yeah, that's the trade secret, I think, is probably like a very difficult manufacturing process with hard materials, because like if you have a chip, right? It's hard for you to reverse engineer and figure out how we made that, all the steps, so that's good trade secret material.
Now
The
you're
technology has a life longer than a patent, then trade secret is good.
a lot of it's just, like, it's not first to market, if you get market share, nobody's gonna try to, but
And then you attach a trademark to it, so everyone knows that trademark is associated with this product that is really good, and now you've just locked it in.
You